Hello, John Dove here from Speed Mooting. Welcome to the latest episode of the Partners in Crime podcast. Today, Hayley and I discussed a variety of different topics, and we hope you enjoy listening to the podcast. We began by answering some questions that you've been sending in advance. We're enjoying answering these questions. If you think of any, please feel free to drop us an email, info@speedmooting.com. We also talked about some previous experiences that we had with interviews. So we spoke very specifically about our first ever interviews, or rather Hayley's first ever training contract interview, my first interview in general as a teenager, and how we got these wrong, and the mistakes that we picked up on and lessons learned from these interviews. We discussed Justin Timberlake, who's been arrested in the United States, and we discussed the equivalent offence in the UK. We discussed the purpose of a defence in civil litigation. We discussed the purpose of a defence statement in criminal litigation. And then we finished with a brief roundup talking about our week. So once again, we enjoyed recording the episode, and we hope you enjoy listening. Welcome to the podcast. Hello and welcome to the next episode of the Speed Mooting Partners in Crime podcast. My name is John.
And I'm Hayley.
And welcome along.
Episode 13. Unlucky for some.
Unlucky for some.
Not for us.
Yeah, it'd be nice and lucky for us. For those who are new to the podcast, what we like to do is every week we name our podcast. Normally it's been named after Formula One drivers, and then
footballers.
Footballers.
Kind of got on to Olympic sports people last week. It was all a bit strange.
Yeah, we didn't name the episode after Olympic athletes.
No, we didn't, but we had a good chat about them.
We've chatted about them, yeah. Long story. Thankfully, it's business as usual. Number 13, we're back onto Formula One. Do you know who number 13 will be on the current numbering system, Hayley?
No, I need some clues.
Okay. I mean, to be fair, you're never going to get it, even if I give you any clues.
Don't underestimate me.
Okay, he's from Venezuela.
No, means nothing.
Okay.
Anything else?
He won the 2012 Spanish Grand Prix.
Is he still a driver?
No.
Oh. Don't really know any old ones, do I?
Probably not, no.
Go on, put everyone out of their misery.
It is Pastor Maldonado. So he was probably in the sport for about 5 years or so, maybe slightly longer. He was pre-2018, so the Drive to Survive people probably won't know him.
Oh, okay.
There's a bit of a divide in the Formula One community. There's people like myself that have been watching Formula One forever, and then people who've come into Formula One post Drive to Survive, and then there's a bit of animosity there, I think, in the community. My view is, do you know what? If it's bringing new viewers to the sport...
Why does it matter? Keeps it popular, doesn't it?
Exactly. My view is, if it brings new people into the sport, new viewers, great. And do you know what? There's been loads of new things that have been introduced since 2018. So do you know what? The sport's going from good to great. So
yeah,
I'm all for it. If Drive to Survive has brought new people, new fans, and it's helping the sport expand, perfect.
There we go. My route into Formula One wasn't Drive to Survive, it was just knowing you. I often say there's only so long you can listen to someone talking about something before you have to just take an interest in it.
Let's move on. Anyway, we're on it's the episode 13, the Pastor Maldonado episode.
Welcome.
Let's get back into the law.
It's early in the morning, which is why there'll be a heavy amount of coffee during this podcast.
We thought, you know what? I'm not recording till the afternoon. Let's record the podcast Monday morning.
We've had a lovely little weekend now, haven't we?
Not been a bad weekend at all, has it?
No, it was very nice. So we went out dancing on Friday.
Oh, yeah.
That was fun.
Yeah.
What did we do on Saturday?
Saturday we did a bit of work, didn't we?
We did a bit of work. We did a few little nice walks.
Yeah.
And then a bit of a chill day, wasn't it?
Yeah, took it easy.
And then Sunday went kart racing. Well, yeah. John went kart racing. I went kart watching. But it was lovely. The sun was out. We caught a little bit of sun.
Yeah, you can probably see we're nice and red at the moment. Don't know if you can see on the camera, but...
You don't look too bad this morning.
Yeah.
Yesterday, you looked like a little lobster.
thing was because, I was inside the awning working on the cart most of the day, and then whenever you go to the track, you wheel it down, you're in your suit. So I didn't think I'd catch much of the sun, but we did spend a little bit of time.
We did, sitting when we were waiting for you to go on track, weren't we? So
Yeah.
that's probably what did it.
Yeah, so...
But fun little weekend, so we are feeling nice and refreshed and ready for a fun week ahead, aren't we, John?
Yeah, definitely. So we'll start with some questions, and I think we've had some questions come through via email, haven't we, Hayley?
We definitely have. So firstly, I'll just mention we had our mooting course last week, didn't we, John?
We certainly did.
Massive success. I think it was our biggest attended online event.
It really
was. Online free event so far.
Yeah.
Really, really good. And through that, we only had an hour. we got over 50 questions before the session.
Wow.
And then through the session, we had everything coming through the chat box. I was there frantically copying and pasting it. So we got an awful lot of mooting related questions to get through over the next weeks, months, maybe even years. Who knows? So I'll do one mooting question, and then we've had all the questions come through via emails and comments, etc. So we'll do a mooting question and a non-mooting question.
Yeah.
Sound good?
Sounds good.
Okay, so the mooting question firstly. What is the best way to prepare for a mooting competition?
Okay, all right. So first things first, read your moot problem nice and carefully. So you'll normally have a case summary, which is not particularly long. Case summary will set out the undisputed facts of the case. So when you read that, check which side you're acting for, it will tell you, and check what the areas of dispute are. So normally it might tell you these are the grounds of appeal, so it'll set them out nice and clearly so you'll know what's in dispute, and that will help you focus your research if it is an old school moot unlike ours where you've got to do some research and drafting. So when you start that preparation, that's when you're going to start all the research. So first things first, I would say, is look at the textbooks, because normally they're going to be based on academic problems that you'd be covering at university anyway.
Yeah.
So if it's a contract law moot and it's on offer and acceptance, we'll go to that chapter of the textbook. Start there, have a read, make sure you understand the principles. It might set out some key cases for you to have a look at. Then from there, once you might have seen what all the key cases are, and then you need to expand your research. So go online, go on your legal databases, your Lexis, your Westlaws, probably others are available, I don't know. But then do some more guided research on there to look for any case law that's going to support your argument. And that will help you formulate your arguments from there. Then, of course, once you've got your argument, you know which cases you're going to be relying upon, you then need to draft your skeleton argument. And as we mentioned on the course, the skeleton argument is skeletal. It's the bare bones of your argument. So then once you've got all your research done, you know which cases you're relying upon, you've drafted your skeleton, practice, because you don't want to have a script that you're reliant upon that you've never practiced previously. You go into the moot and you just literally read that verbatim.
Yeah.
Practice your moot. There's no minimum number of times. The more you can practice it, the better, because the more you practice, the more familiar you become, the more dynamic you become in your presentation of the moot, so that it becomes a dynamic presentation when you're in the moot room, rather than a wooden, today my submissions are these, point one,
Yeah.
So
practice yourself, practice with your friends, your family, practice in front of a mirror, record yourself, watch your back.
Kim, you're doing amazing, sweetie.
100%. And the more you do that, as I say, the material becomes ingrained in your brain, it becomes second nature to you. And then that way, if you're on point one of the skeleton argument and the judge says, well, I'm more concerned about what you've said at point three, can you address me on that? Fine, you know that, you can flick to it, you can jump there right away.
Yeah.
So you're able to jump and you can deal quite flexibly with the material. So that's what I would say in terms of preparation for a moot.
Brilliant.
And how you can effectively prepare.
Very good. I think on that note, so we have a mooting competition coming up, don't we? So our next in-person national speed moot is coming up on the 7th of September at BPP in London Central. So it might be worth, John, just setting out the differences between our moots and a traditional moot.
Yeah, absolutely. So the key difference with our moot is that we supply everything for you. So there are pre-drafted skeleton arguments included, and all of the case law and legislation is included. So that means there's no research and no drafting for you. Because we recognise how busy you are as a student, or even if you're in work, because our competitions are open to people who have graduated from any course. Basically, our competition is open to anyone as long as you are not practicing as a barrister or solicitor.
Yep.
So the opportunity is there for anyone. We know how busy you are, so there's no research and no drafting involved. You get the problem the night before, so it's like being in practice when you get a late brief, because you get late briefs all the time in practice. The number of times that I get a brief an hour before due to going in court is unbelievable, so it happens fairly regularly. So you're getting the brief fairly late on, and we ask you to prepare for both sides, because our competition involves 128 people. The winner will go through 7 rounds in the course of that day. So from one round to the next, you won't know if you're for the appellant or the respondent. So that's why we say prepare for both.
Yep.
Because you've got to flip and flop between the two.
Brilliant.
And the other nice thing about our competition is that it's one-on-one. You enter as an individual, so you're not reliant upon a mooting partner that might not put the same amount of effort in that you might, that might not have the same advocacy skills that you have.
Yep.
It's all down to your effort and your skills.
Yeah.
So,
and you're not relying on being chosen by your university to come along.
Yeah.
You can sign up completely
well,
independently.
Yeah.
And we could have 50 people, we often do, 50 people from one university. If that's how many people choose to sign up, it doesn't matter.
Precisely. There's no limit to the number of people from one uni that can sign up, because that was a problem when I was at uni.
Yeah.
You know, I wasn't in with the right clique. I would never be selected for mooting competitions. So I had no opportunity to enter external competitions. So we say, no, you're entering on your own. You don't need to wait for your university, your law society, whatever it is to put you forward. If you want to go have a go, get on our website and sign up.
Yeah. And of course, a big difference that comes from, might be a hint from our name, is our submissions are severely shorter.
Yes.
Speedier than a normal moot. I mean, I don't know, so ours are 7 minutes long, aren't they? And then the final is 10?
Yeah.
How long is a traditional moot? About 20? I never did any mooting.
So it's 2 on 2. So normally senior counsel speaks for 15, junior counsel about 10.
Right.
So you tend to find that each team does about 25 minutes worth of submissions. Sometimes it can be longer. You know, it's every competition has its own time limits. But from my experience of our internal competitions at uni, I think it was 15 for senior, 10 for junior.
Well, there we go. That's a little bit of a difference between speed mooting and normal mooting competition. So sign up is very, very healthy.
It is.
As these competitions always are. London is always super popular as well. So get along to our website if you want to join us on the day.
Yeah, a very good chunk of all the places have gone so far. People say to us, when do you close sign up? We close sign up once all the places are gone.
But there we go. Speedmooting.com, and there's links all over the homepage for the Autumn Cup. Yeah. So sign up and we look forward to seeing you there. And if you have any questions about the competition, info@speedmooting.com.
Exactly.
Next question.
Next question, please.
Okay, so I'm going to get a non-mooting related question. It's got such a long list of questions. It's exciting though, because it's like months and months worth of content right here.
So much content for us.
Okay, so this is a good one. So what are the differences between cross-examination and examination in chief? And this was actually asked from somebody so they can practice playing both parts, so when they're building up their own advocacy skill. Okay. So this is very well timed, because we actually did a couple of social media posts last week, I think, and we just gave a very brief outline of what cross-examination was and how an advocate deals with that, and what examination in chief is and how an advocate deals with that. So maybe give an overview of the two, John.
So examination in chief, or evidence in chief, and cross-examination refer to the way in which a witness is examined at trial. So what happens is, so let's say you've got a trial, and it doesn't matter whether it's a civil or a criminal trial, a witness goes into the witness box. When they are being examined by the side that's calling them, so let's say it's a prosecution witness for argument's sake, the prosecution barrister will go first and ask them a series of questions through evidence in chief for that witness to tell their story. Then the other side, once they've told their story, the prosecution barrister has asked as many questions as they want. They sit down, the defence barrister stands up and puts a question to them in what's called cross-examination, and that's their chance to try and challenge that person's evidence effectively. So
the examination in chief is a lot more friendly. It's just taking someone chronologically through the story. Yeah. And the cross-examination is where it gets juicy.
Pretty much, yeah. Well, it can do, yeah. It can do. So evidence in chief first. So traditionally, a person will draft a witness statement and they'll have the witness statement, but they can't have that witness statement in the witness box with them.
I think they can in civil proceedings, can't they?
I don't. Well, yeah, they will do actually, because in civil it's a lot more simple.
Yeah,
so
I'm sure someone on one of our social media posts, we had a civil barrister that commented and was like, so much easier in civil. You say, is this your statement? Is this your signature? Thank you.
Yeah, pretty much. Yeah, you don't do live evidence in chief unless you want to add anything supplementary. So if
Right.
something that's not covered in the witness statement, then you'll ask questions to include that information.
Yeah.
But yeah, back to criminal, because that's what we'll deal with this because that's where evidence is given live. So you won't have the witness statement in the witness box with you, and what the barrister who's examining that person is trying to do is get that witness to give all the information that's in the witness statement. And the way in which you need to do it is you need to ask open questions. Open questions are the name of the game. You shouldn't really be leading the witness unless there's something non-controversial. You speak to your opponent beforehand and you go, are you okay for me to lead on this, this, this and this? Because it just saves time. If it's not controversial, why do you need to go through the rigmarole of open questions when you can just lead on the information?
Yeah.
But let's put that to one side. Let's assume there's no agreement. Let's say you're getting all the information out. Mm-hmm. So it's all about open questions. So as a general rule, an open question doesn't imply the answer. So for example, to give an example to you of the difference, Hayley, if I said, what colour shirt are you wearing? Mm-hmm. What would your answer be?
Pink.
Yeah, okay. And that's an open question, isn't it? Because it doesn't imply the answer.
Mm-hmm.
If I said, you're wearing a pink shirt, aren't you?
Yes.
That's a closed question because it implies the answer.
Yeah.
So, as a general rule, an open question begins with H or a W. Who, what, where, when, why, how. A closed question, generally, yes or no answer.
Got it.
Okay. So the idea with your evidence in chief is you're trying to ask open questions to get that witness to give their evidence. Now, you can use what's called a piggybacking technique because you can't introduce out the blue just a random piece of evidence. So coming back to your t-shirt, I couldn't just introduce the fact that you're wearing a pink t-shirt. I'd need to ask you about that initially. So talking about the piggybacking technique, let's say I said to you, Hayley, what colour is your shirt? And you say pink.
Yep.
I can then say, how many sleeves does your pink shirt have? So you see the word pink, the pink shirt, I can now introduce that into future questions, but it's only because you've introduced that piece of evidence.
Yes, yeah.
Okay, and so I say, so how many sleeves has your pink shirt got? You say 2. Mm-hmm. And what is the length of the sleeves on your pink shirt? Like that. So you see how with the piggybacking technique you can start using information from previous questions to guide your future questions.
Yeah.
But long and short, the name of the game, it's all about open questions with your evidence in chief. Cross-examination, as we say, that's all about trying to undermine the evidence of the witness that's in the witness box.
Yeah.
And the reverse is true. So closed questions are very much the name of the game.
Mm-hmm.
So and closed questions are actively encouraged. So you're not limited to only asking open questions. If you're with me. As I say, with cross-examination, it's all about trying to put your client's case to a particular witness or trying to get something that's helpful from the witness.
Yeah.
With cross-examination, don't spend too much time in there. Get the information that you need and get out. There's always that risk that you ask one question too many and the witness gives an answer that's unhelpful to your case. So get in, get the information that you need and get out. Yeah. And it doesn't need to be cross, you don't need to be angry. You can use a much more gentler approach and the witness might be much more amenable to giving you answers, so you don't have to be cross or angry with a witness. Yeah. In actual fact, there's no real need to be cross. You're going in to do a professional job, so why would you be angry with a witness? You're putting a case on behalf of your client, ask the questions, do what you need to do, and get out. As I say, the key thing really is closed questions because it gives the witness much less wiggle room, as it were. Yeah. It's a series of yes or no questions rather than please explain, because sometimes they might explain and it's not particularly helpful to your case.
And I think we've talked about it before, haven't we? It's almost it's not as important what the witness says rather than what questions you pose, because you've got to put the case. So you see it on television, don't you, when they'll always like, come on, you killed him, didn't you? Okay, yes, I did. In reality, that doesn't really happen, but as long as you've put your case, they can keep saying, no, I didn't, no, I didn't, no, I didn't, but it doesn't matter. You can still say, well, I'm going to say that you did, and you can still put that case, can't you? I was watching one of our old Q&As last week when I was doing these social media posts, and someone was saying, I think it was Callum Brooke, who's a family barrister, was saying, you know, they don't give you the answer you want, you can, you know, ask it again. And sometimes you look to the judge, and then the judge will be like, answer the question, you know, if they don't answer the question that you want them to. But it almost doesn't matter, because as long as you've put the right question, you've done your job that you need to do for your client, haven't you?
Yeah, it's just about hanging it out there. So, you know, there's an obvious sort of question that goes, you know, to somebody's evidence, you know, something that they say that just doesn't quite ring true. You ask the question. They're obviously, you know, they're never going to give you the answer that you want, as you say. But it's just about hanging it out there, particularly for the jury. Because, you know, the jury are thinking, that doesn't quite make sense. You know, they're thinking about it anyway, so it's not so much the answer that's important. Quite often it's just the question. So, as a general rule, what we were taught was, during evidence in chief, the spotlight should be on the witness. They're the one giving the evidence. During cross-examination, the spotlight should be on the advocate that's doing the cross-examination.
Interesting, yeah.
Because ultimately, as you know, as you've said, Hayley, they're never going to confess. They're never going to give you the answer that they want. So it's all about just watching, you know, the tribunal, watching you put your case, seeing the case be put, but also listening carefully to the questions and thinking about the questions that are being asked there. So I hope that's helpful. I hope that gives you a bit of an indication of the difference between examination in chief and cross-examination. And ways that you can practice. So, you know, if you've got any old examples of, I'm guessing this is somebody that's been on the bar course, so maybe you've still got some examples there where, you know, you've got a bit of a trial pack, a few witness statements for one side or the other. Get a few of you together and practice. Get one of you playing the witness, one of you playing prosecution, one playing defence, or claimant and defendant, etc. And just have a practice, have a bash at it.
Yeah. There we go.
There we are.
And I think that concludes our questions for this episode.
That concludes Question Corner.
Ask Speed Squad.
Ask Speed Squad. Yeah, Ask Speed Squad. Let's go with that. So, we've been talking about interviews lately, haven't we, Hayley?
Yes.
We have some random conversations, but yeah, we were talking about interviews.
We often have random conversations, and we say, oh, we need to speak about this on the podcast.
Yeah. But actually, before we move on to interviews, there was something else we were talking about recently, and another. When we talk about these interviews, these are silly examples of things that we've done wrong in interviews. But I remember something else I did, which was, well, I didn't even get an interview, and quite rightly so. So, not far from me, there's a Spanish law firm. Okay.
Oh. I know where this is going. Yeah.
And I remember years and years ago, it must have been, I don't know, I was probably a teenager or something, you know, probably 18, 19, and I must have been after, you know, a summer job, as you do. And I was going around loads of law firms by me and went into this Spanish firm, and I must have gone in with a CV, and speaking to somebody in there, said, I'm coming in with a CV, I'm interested in applying for a paralegal job over the summer. And this individual said, oh, okay, right. So what we do is, you know, I think they deal with sort of conveyancing of Spanish properties, so people in Britain who are buying properties in Spain, so they deal with the law in here and law in Spain.
Yeah.
She explained that to me. She goes, so have you got an interest in Spanish law? Not really, no. Anyway, conversation went a bit weird from there, and she took the CV from me, and lo and behold, I didn't hear from them again.
Strange.
And I just think that's a funny story. I mean, what was going through my mind to go in, hand the CV in, someone says, have you got an interest in this area of law? No.
At least you were honest.
I mean, I was honest.
What were you doing in there in the first place?
What was I doing in there in the first place? I mean, so long and short, you know, I often say to people, you know, when you're looking for jobs, you know, think outside the box. Don't just go on and go, oh, do you know what? This firm's got an online application form, and that's all you can do. You know, if they're nearby, feel free to go in and have a chat. You know, it's a good way of introducing yourself, setting the tone, and it shows that you've got a bit of confidence and gumption, because not many people have got the guts to do that these days.
We were in a retail shop, weren't we, the weekend, and we saw a young girl coming in, handing a CV in and asking to speak to the recruitment manager, and we were like, gosh, I bet that hardly happens anymore.
Yeah.
And the woman at the till was like, let me call someone, because
you just don't see it.
when we were younger, like I remember when I was looking for like a weekend job, that's literally what I did. I had like a batch of like 40 CVs, just went into every shop in town and spoke to the manager.
Yeah.
So it gets you places, doesn't it?
It does.
Shows a bit of gumption.
But coming back to my story, and the key thing I would say is think about what you're saying to people.
Yes, and make sure you only target places that you have a genuine interest
target
in.
places where you've got a genuine interest. And think about questions you might be asked. So that was a lesson there from me.
So we've got some very similar stories, haven't we, from interviews?
Yeah.
So mine was my first training contract interview. It was just a small high street firm. And, you look back and you think I was so not ready. And it was a second year of university. So I was like, oh, here we go. So it's all going to happen the way it's supposed to. I'm going to get a training contract, start it right after university. Everything's going to... No, didn't really work out. And I can't remember a lot of it because it was a long time ago. But when you just want the ground to open up and swallow you for a lot of these questions. The one that always sticks with me is when the partner said to me, so like, what do you think's the most important thing like for us as a business? And I was like, you've got to keep your clients happy. And he was like, anything else? Like, well, you've got to make sure you all know the law. And just stupid answers. And after about watching me squirm for about 5 minutes, he was like, it's making money. I was like, of course it is, but you're so naive when you don't understand business. At that age. I didn't. Probably didn't have an ounce of commercial awareness at that age. So I was like, I didn't even know that was something you could say. And he said to me, like, it's okay to talk about money. We're here for our clients, but we're also here to make money.
It's got to be, hasn't it? Because at the end of the day, law firms are businesses. That's why they're in business, to make money.
Yeah.
And that's the reason that people go into firms. They want to progress. They want to make a partner. They want to, move up within the ranks within the firm, because people want to move on.
Yes.
And it makes sense, doesn't it? At the end of the day, law firms are businesses. It's all about making sure that they're as profitable and reducing costs in the right way, basically. So yeah, I mean, it 100% makes sense, and I think
it's not taboo to talk about it.
It shouldn't be anyway. It shouldn't be, and also, I think that's, people talk about commercial awareness. That's the number one aspect of commercial awareness, I would say. Think about whichever firms you're going into, or chambers, whatever. How is it that they make money?
Yep.
What is their fee structure in terms of, do their clients pay privately? Are they on a legal aid basis? Think about how they get paid. Do their clients pay privately? And then is that on an hourly basis or a fixed fee? Mm-hmm. Do they get paid through legal aid? Whatever it might be, think about how they get paid and how they make money and how they are profitable. That's the number one aspect of commercial awareness, isn't it? Yeah, I think to clarify, we're not advocating, go in there and just simply be all about money and don't care about law and just... But
the best lawyers know the business of law. They've got to.
100%. Yeah.
What was your funny interview story, John?
So this was from sixth form. So would have probably been year 13. So I'd have been 17 at the time, and the head of sixth form knew I was interested in law, and we had this opportunity. I don't know how, but some firm had written into the sixth form. It's like a financy type firm. So we're looking for a summer intern or a summer. It's basically a summer job that we've got, and we're looking for people who might be interested in this role. So the head of sixth form told me about it because I was interested in law. It's quite linked. I said, I'll put an application in. So I put an application in, got an interview, and I went for an interview. First interview I'd ever had. And I don't remember much of the interview, and I probably didn't answer the questions very well because I've never been through an interview or anything like that before. And then they say to you at the end, they go, any questions? And the advice that people give you, particularly in relation to pupillage and training contract interviews, is go in, think about questions that you've got, try and ask at least 3.
Yep.
But questions that show you're interested. So what sort of team would I be in, what sort of work would I be exposed to, stuff like that. I had one question like, so how much am I going to get paid for the 6 weeks? And they're like, Yeah, we'll discuss money later, or some fob off answer, because I knew, even I wasn't that naive enough to know I did terribly in an interview. Lo and behold, I didn't. Well, either didn't hear from or I got a rejection letter, but I didn't get the summer job, and quite rightly so, to be fair, and messed up the interview. But when I think about it, it just reminds me of that episode of The In-Betweeners where Neil goes on work experience and he goes, so how long's my lunch hour?
Right. And do you have any questions you'd like to ask me about anything?
How long's my lunch hour?
An hour.
Very, very similar to that,
I think it's it's a good lesson though, isn't it? Like we have to go through this thing, and everyone's going to be terrible at the first interview, or you would expect so. Yeah. And you have to learn, like that question I got about, well, it's money, and it was like, of course, that was like a light bulb moment. Of course it is.
Yeah.
Everyone has to go through these experiences to learn and to grow.
That's the only way that you learn. You need to go through. You need to. Because no matter what you do, you're going to be bad at it the first time, whether it's an interview, whether it's advocacy, whether it's, pick anything, you're going to be terrible the first time. And that's the only way that you improve. Yeah. If you look at our podcasts, I'm sure that our first podcast was probably not as good as the high quality that this podcast hopefully is. So anything in life, just go through, have some bad experiences, get knocked back, and you'll get better in time. Yeah. You'll get better in time. So, commercial awareness corner. Nice little segue there, Hayley. We're talking a bit about commercial awareness corner. Mm-hmm. There's been quite a significant arrest in the United States in the past few days, hasn't there?
Oh, yes.
Justin Timberlake. Fall
from grace.
Yeah.
Or maybe not. He hasn't been found guilty yet, as far as I'm aware.
Yeah, I mean, he's innocent until proven guilty, just like anyone else, but he's been arrested nonetheless.
He's been arrested, and already he's been turned into a meme.
He has indeed. The mugshot photos get released out in the States, don't they?
Yep.
Yeah. So he's been charged, hasn't he, with failing to provide a specimen. So my understanding of the case is that he's been arrested, taken to the station. They've wanted to take a sample for either drink or drug driving, I don't know which, and he's failed to provide. Now, thankfully, this is a story I actually can talk a little bit about, because this is within my wheelhouse.
Right up your alley, isn't it?
I'm a motoring specialist. So I'll talk about this from a British law point of view, because I don't know which state he's been arrested in and what laws are out there. But, Section 7.6 of the Road Traffic Act 1988 makes it a criminal offence in this country to fail to provide a specimen when required. So what tends to happen in this country is, the police can pull you over, if they suspect that you've been committing an offence. So normally it's if you're swerving, speeding, excessive braking, something like that. They see you driving's not up to standard, they'll pull you over. Yeah. Or it might be, a routine check. Say you've got your illegal licence plate or your brake lights are out or whatever, so you pulled. And then if the police suspect that you are over the limit for drink or drugs, normally it's through smells, certain aromas coming from the vehicle, slurred words, enlarged pupils, particularly constricted pupils. They can require a roadside breath test, so that's where you blow into a handheld machine, or if they think you're over the limit for drugs, they'll take a swab, and that will show up with an initial reading. So it might show that you're over the limit. Now, those are not evidential. They're just simply enough for you to be arrested and taken into the police station. Yeah. And then once you go to the police station, that's when they will take the evidential sample from you. So if it's drink driving that you're over for, you'll have to blow into a large machine.
So I was going to ask, just stop you there. Is it an offence to refuse at the roadside and at the station? It doesn't matter which one you refuse.
Yeah, but they're separate offences.
Right.
So the roadside refusal is, I think that comes under Section 6 actually, but it's not as severe. So if you refuse at the roadside, you're only looking at points. So it's 4 points for failing to give a roadside specimen.
So that's if you refuse at the roadside, are arrested, and then when you get into the station, you do it.
Yeah.
Yeah.
But they probably wouldn't charge you with that, to be fair.
Because you gave it later on anyway.
Ultimately, you've given it anyway, so it probably wouldn't really be in the public interest.
Yeah.
But But they're two completely separate offences. But the more important offence is the evidential one, because you're potentially avoiding a prosecution for the more severe drink or drug drive. So once you've given a positive test at the roadside, you'll then be taken into the station, and if it's drink driving, the police can request a breath sample. If that's unavailable or you can't provide for any reason, they can move on to blood, and then if that's not possible or you can't provide, then move on to urine. However, if you fail to give a sample that's requested by the officer and your refusal is without a reasonable excuse, then you can be prosecuted. So failing to provide without a reasonable excuse is an offence. And for drug driving, it's only blood that can be taken. So you can't give a breath sample because they can't detect it accurately in breath.
Yep.
And likewise in urine, the testing isn't accurate enough, so it's got to be a blood test for drug driving. And the same applies. It's failing to provide without a reasonable excuse is an offence in law.
Okay.
So it sounds to me from
does
the
our
report,
Justin Timberlake have a reasonable excuse?
well, that's it, yeah. Is that going to be his defence? Or is he going to run a technical defence? Do they have an equivalent to the MGDD forms in the United States that they would want to run a technical defence?
Maybe.
Who knows? It'll be interesting to see what his defence is anyway, but...
Let's watch that one play out.
Yeah, if he needs a decent barrister, I'm sure I can go and get a law licence in the States for a few weeks.
Yeah. We'll pop over to America and sort you out, JT, don't worry.
Yeah. So anyway, that's Justin Timberlake.
There we go.
So last week, Hayley, we were talking about the particulars of claim in relation to civil.
Yep, we had a little overview of claim form, particulars of claim, commencing claim, didn't we?
Yeah. Now, once the particulars of claim have been filed and served...
Filed and served, yeah.
I think that's your civil technical terminology. What do the other side have to do?
Well, funny you should ask, John. So the next stage in a general civil litigation claim is acknowledging the claim and filing a defence, if you do intend to defend the claim. So the general rule is you have 14 days to acknowledge, and within that acknowledgement you can either accept the claim, partially accept it, or note your intention to defend it.
Yeah.
You can also file the defence there and then with the acknowledgement if you choose. However, as long as you acknowledge within the 14 days, you get a further 14 days to file your defence.
Right.
So 28 days from the date you were served with the claim form and the particulars of claim to file your defence. So the defence itself is very similar to the particulars of claim which we were discussing on last week's episode. So it's a can be a pretty meaty document that goes through, the way we would always do it in commercial firms is we would go through paragraph by paragraph the particulars of claim, and it might even be to say, paragraph 1 is accepted, because that just names the parties. Paragraph 2 is accepted. Paragraph 3 is disputed, the claimant's put to strict proof. So you'll go through each paragraph and defend the claim.
Okay.
So it's really, really crucial, the defence, because what happens once the defence is filed, it can, obviously the matter runs right through till trial, and we can cover the step-by-steps to trial another time. But what we would tend to do, if we act for the claimant, once we get the defence, it's like, yay, because quite often, if we have to litigate, it's because the defendant hasn't revealed their case or their position yet.
Right.
Obviously, they have to when it comes to their defence. So we litigate for one of two reasons. Either, we don't have a choice because the defendant isn't coming to the table, they're not negotiating with us, they're not telling us what their position is, or because we know, our claim is absolutely nailed on, and they've not paid up or they've not settled with us. So one of two reasons is the main reason why we hit that litigation button. So if it's the initial reason, we don't know what their case is or what their defence would be, once we get it, it's like, yay! So we can then take that defence to counsel and ask them to give us advice on the merit of the defence and the strength of the claim. So if they'll say, this is when we get our prospects, if they say this is a really weak defence, they've got no case, then we can make an interim application, an application for summary judgment, and we can get the case dealt with there and then without having to go all the way to trial.
Right.
Or if they say to us, this is a pretty strong defence, we can up our efforts to settle and make sure we do settle very early on, to limit, criticism over cost recovery and to avoid going to trial. Because I've mentioned before, very, very few cases
No, not at all.
get to trial. So yeah, it's another major pivotal stage in any proceedings. And again, if you're acting for the defendant, quite often we would get counsel's assistance to draft the defence for us.
Yeah. No, it's funny you should say that, because I think I worked on litigated cases in civil for about 2 years. So I worked on employers and public liability cases. 2 years, we had 3 trials.
Yeah.
Just never get them at all.
And it's because it's so expensive. Like any trial that we would run in property litigation, you're talking 50,000 minimum. Usually higher than that.
Yeah.
And even if the cases is worth hundreds of thousands, you really want to spend 50,000 on legal costs if you don't have to. So if you can settle, it often saves you money if you can settle early on.
Yeah, that's the way to do it.
Yeah, I say the exceptions are the smaller scale things. So possession claims, Section 8 claims, Section 21 claims, which is evictions of just rented properties, etc. They go through the court process. I won't say very quickly, but quicker than trial. Yeah, so that's the 2 main reasons we don't get to trial very often. A, it's so expensive, and B, it takes so long. So you can be waiting over a year to get a trial date.
Wow.
You can be waiting months and months and months just to get your claim issued.
Yeah, it's super speedy compared to crime.
So yeah, that's a little insight into the next stage in civil litigation.
Oh, well, sticking with written defences, I'll talk a bit about the defence statement in crime.
Please do.
So the defence statement arises once the prosecution has served its full case, so once the prosecution have served all the evidence in the case, and once they've provided unused material. So what happens is, the prosecution will provide what's called an MG6C, so that's a schedule of unused material. So that's anything they're not relying upon as evidence as part of the case, but documents that they may have, things that they may have in their possession. And within that, they'll mark each off saying whether it's clearly not disclosable, whether it's not disclosable, and whether something is disclosable. So the purpose of the defence is to set out what your defence is. It sets out anything that you dispute in relation to the prosecution's case, anything that you don't accept, but also, coming back to that schedule of unused material, anything that you think you may be entitled to, you would set that out within your defence statement as well. So you'd effectively be making requests for disclosure of various items. So it's whether you think that something meets the disclosure test. And what that means is that whether one of those items on the prosecution schedule either undermines the prosecution's case or is likely to assist the defence case, you'll put them on there and you'll say, yes, that's what we want. So that's the purpose of the defence statement. Now, in the magistrate's court, they're completely optional. And quite often, for most cases, you probably wouldn't see a defence statement. The only reason you would ever put together a defence statement is if you've seen something on the prosecution schedule and think, we want that, that's going to help our case, that's going to undermine the Crown's case. In the Crown Court, they are compulsory, so you must serve a defence statement, and you must serve it in line with the date as set out by the judge at the pre-trial preparation hearing. If you either serve your defence statement late, if you don't serve a defence statement at all, the judge is entitled to give a direction to the jury at the end of trial to draw an adverse inference as to why it is you've served your defence statement late or not at all. So that's just a little insight into the defence statement in criminal proceedings.
There we go.
So I think we've covered most things there.
We've got a bit of a quiet week this week, haven't we, John? I think you're doing an event on Thursday.
Yeah, an event on Thursday for BPP. P.
Yep.
I am running the Advocacy Club tomorrow night.
Oh God, it's Advocacy Club tomorrow
Advocacy
night.
Club.
It's not that quiet. It's not that quiet
not
this
quiet
week.
at all. And it clashes with the England game, so it will be interesting to see what attendance will be like this week.
Well, obviously, who is going to choose England football over Advocacy Club?
Yeah.
No one.
I mean, in fairness, Advocacy Club will be much more exciting than watching England play football.
Exactly. So,
yeah.
come along and watch us. Yeah, Twitter session on speed mooting tomorrow.
All about speed mooting.
So if you're planning to, or you've already signed up for our speed mooting competition,
it's a great way to get some practice in.
You'd be a fool to miss it.
Unfortunately, by the time this podcast goes live, the session will have taken place. So
you might sit there and go, "No, I missed it." But don't worry, because we always record the little segment where John gives some advice, hints and tips, and that will go on our YouTube channel. So
it will.
All is not lost.
All is not lost. And of course, if you still want to take part in the competition, you're still welcome to do so. If you want to practice speed mooting, we run speed mooting sessions several times a year at the Advocacy Club, so there'll always be further chances to practice.
Indeed. Yeah, I thought it was a quiet week. We've tried to make it a little bit quieter, haven't we? Because we've got a holiday coming up.
We certainly have.
We're off to Seville.
Seville. Should be good.
Very excited. Do you want to tell the story about how we decided to go to Seville?
Yeah, let's do it. So we've been watching the Mission Impossible films recently. And
I've never seen any of them, so we thought we'd go through them.
Yeah, I've possibly seen 1 and 2 many, many years ago, but I didn't remember them anyway, so we thought, yeah, we'll watch them. And I'll tell you what, they're good films, aren't they?
They are good films, yeah.
They're really good films. So we're partway through the third one at the moment. And in the second one, they go to Seville, and it looked incredible, didn't it?
Yeah, it looked really nice.
So we were
I think within 10 minutes of that's Seville, we'd booked a holiday to Seville.
Why not,
Yeah, we can be quite
spontaneous people, aren't we?
Spontaneous people.
Spontaneous, so that's it. Watch Mission Impossible.
Yes.
Book the trip to Seville.
That's it. So, for those who don't know, Johnny has a very basic taste in food. So it's pretty much, pizzas, hot dogs if you can, but obviously you can't eat all that stuff anymore with your
can't eat all that.
list of
changed my diet recently,
yeah. So I'm
on the Novak Djokovic diet now.
You certainly are. So I'm a little bit nervous about what John is going to eat on this holiday. Will we be able to get you to eat some tapas? Who knows? But if anyone has been to Seville and has got some nice recommendations on where we can go to eat and where there's a nice variety of food, so we can find some plain items for John, chips, great, sausage rolls, even better.
Chips, sausage rolls and gravy.
And gravy. If there's anywhere that does spring rolls, well, there we go.
Oh yeah, we're laughing, aren't we?
But yeah, if there is anybody watching and you've been to Seville, we'd love some recommendations on where to go.
Brilliant. Well, that brings us towards the end of another podcast. I've certainly enjoyed recording it. Have you, Hayley?
I've enjoyed recording it, John.
Good to hear. I hope you've enjoyed listening. If you're still with us at this point in the podcast, then
well done.
Well done. Yeah, you've listened to the whole thing. You've had a variety of things discussed, if I put it that way. We've had Formula 1, we've had Justin Timberlake, we've had criminal law, civil law, mooting. It's been a varied podcast, hasn't it?
Certainly has.
So I hope you've enjoyed it all. And
don't forget to like, comment and subscribe.
Definitely. See you next week.
Bye.